The man who won an election, fairly, legally, convincingly, may now be constitutionally forbidden from defending his own record. Governor Lucky Aiyedatiwa of Ondo State did not seize power. He was not imposed. He first stepped in to complete a dead man's term, then went to the ballot box and won his own mandate in November 2024. He did everything the democratic process asked of him, and yet, as of this week, a federal high court has declared that he cannot run again, and the Court of Appeal has refused to stop that case in its tracks. Meanwhile, a war that began in the Middle East is now showing up at Nigerian petrol stations in a very personal way. Prices that were on their way down are now surging past 1,250 naira per litre in many parts of the country, and Nigeria is supposed to be an oil-producing nation. So here is the question nobody is asking loudly enough. When a sitting governor is barred from seeking re-election by a member of his own party, and ordinary Nigerians are paying war prices for petrol they shouldn't even be importing, who exactly is running this country and in whose interest? If you are watching this for the first time, welcome to Naija Update 24/7, where we go beyond the headlines to show you what is really happening in Nigerian politics. Subscribe now and never miss an update. What exactly happened? On March 9, 2026, the Court of Appeal sitting in Abuja delivered a unanimous ruling by a three-member panel. Governor Lucky Aiyedatiwa's appeal was dismissed. The appellate court found no merit in his argument that the Federal High Court in Akure had breached his right to fair hearing. The court went further. It awarded 2 million naira in costs against the governor personally. 3 days later, on March 12, 2026, the Federal High Court in Akure went even further. Justice Toyin Bolaji Adegoke delivered the substantive judgment on the eligibility suit and ruled definitively that Aiyedatiwa is constitutionally barred from contesting the 2028 Ondo governorship election. The ruling cited the landmark Supreme Court decision in Marwa v. Nyako, which held that no president or governor can serve beyond 8 years in total. Who triggered this? This was not sparked by an opposition figure. The suit was filed in July 2025 by Dr. Akindele Ebualo, a chieftain of the All Progressives Congress, the same party, Aiyedatiwa's own party. That detail alone tells you that the real battle here is not between APC and PDP. It is an internal war for the soul of Ondo State's political future. Why is this important now? Because Aiyedatiwa did something constitutionally unusual. He was first sworn in on December 27, 2024 to complete the remainder of the late Governor Rotimi Akeredolu's term, then contested the November 2024 election, won and was inaugurated again on February 24, 2025. 2 oaths of office, 2 administrations, 1 man. Sections 182 sub 3 of the 1999 Constitution and its presidential equivalent Sections 137 sub 3 state clearly, a person sworn in to complete the term of another official shall only be eligible to be elected to that office once more. The courts have now interpreted that to mean Aiyedatiwa has, constitutionally speaking, already used his 1 additional term. Even though his current term only began in February 2025, the clock legally started in December 2024. This is not the first time Nigeria has wrestled with succession ambiguity. When the late President Umaru Musa Yar'Adua became incapacitated and Goodluck Jonathan completed his term, then ran and won a full term of his own, similar questions arose about tenure counting. The difference then was that Jonathan had not been formally sworn in as a completing successor in the same way. His transition was messier, more contested. What makes Aiyedatiwa's case cleaner and more legally dangerous for him is that he was formally inaugurated twice, creating an undeniable paper trail. But here's what the courts have not yet fully settled, and this open question will drive the rest of our analysis today. The Federal High Court. The Federal High Court in Akure had jurisdiction here because the matter involves constitutional interpretation, specifically the eligibility provisions for state executive office holders. Justice Toyin Bolaji Adegoke's court is not a state court. It is a federal institution, which means its constitutional interpretation carries weight across the country, not just in Ondo. The Court of Appeal. The Abuja division of the Court of Appeal, not the Akure division, handled this appeal, which is itself significant. The Akure Court of Appeal had initially directed a stay of proceedings. It was the Abuja division that then heard Aiyedatiwa's challenge to the amendment of the originating summons. The fact that a three-member panel ruled unanimously is important. This was not a split decision that Aiyedatiwa could credibly challenge on biased grounds. INEC, the Independent National Electoral Commission. INEC was named as a defendant in this suit. This is deliberate. The plaintiff was not merely seeking an academic constitutional ruling. He was seeking a declaration that INEC would be constitutionally barred from accepting or validating Aiyedatiwa's nomination papers in 2028. The INEC's position that the suit was premature because they had not yet released an election timetable was rejected. The 1999 Constitution, as amended, sections 182 sub 3 and 137 sub 3. Here is the exact legal architecture. Sections 182 sub 3 of the 1999 Constitution states clearly that any person sworn in to complete the term of another official shall only be eligible to be elected to that office once more. The courts have now interpreted that to mean Aiyedatiwa has, constitutionally speaking, already used his one additional term. Even though his current term only began in February 2025, the clock legally started in December 2024. The surprising institutional fact: Aiyedatiwa and his co-defendant, his deputy, the APC and others, were deemed to have abandoned their processes in the substantive Federal High Court case because they did not actively participate in the hearing. The court delivered judgment largely based on the plaintiff's submissions and those of INEC and the Ondo Attorney General. This means the governor's legal team, while fighting the procedural battle at the Court of Appeal, allowed the substantive case to advance almost unopposed. That procedural miscalculation may prove to be the most consequential legal error of Aiyedatiwa's governorship, but the story does not end there, because the political game beneath this courtroom drama is far more complex than it appears. Who stands to gain? The most obvious immediate beneficiary is anyone within the APC in Ondo State who has gubernatorial ambitions for 2028. But that list is longer and more complicated than you might think. Deputy Governor Dr. Olaide Adelami is in a peculiar position. She was also named as a defendant in this suit, and the constitutional question about completing Akeredolu's term applies equally to her. If the court's logic holds, her eligibility for 2028 is also under a cloud. This could clear the path for an entirely different set of Ondo APC politicians, those who have been waiting in the wings precisely because Aiyedatiwa's incumbency made a challenge unwinnable. The internal APC civil war. The plaintiff, Dr. Egbualo, is not a random litigant. APC chieftains in Ondo State have had fractures running beneath the surface since the Akeredolu era. Akeredolu himself was not universally beloved within the party structure. His hand-picked loyalties have jostled with older APC networks rooted in the southwest political machinery. The filing of this suit from within the party is a signal that the political succession battle for 2028 Ondo has already begun, 3 years before the election. The Abuja dimension. Here is where it gets interesting. National-level APC power brokers, including those connected to President Tinubu's political network, have a stake in what happens in Ondo. Southwest states are the core of the Tinubu political base. Who controls Ondo State in 2028 will matter for the 2027 presidential cycle. A governor who is constitutionally term-limited, even if cooperative, is a weaker political asset than a freshly elected governor who owes their ascension to the national political machinery.
The filing of this suit by an APC insider, rather than an opposition figure, raises the question: was this a spontaneous act of constitutional patriotism, or was it encouraged by forces with a clear interest in opening up the 2028 Ondo race? The silent power brokers. Watch for the following signals in the coming months. Which APC figures in Abuja begin making increased trips to Ondo State? Which political consultants associated with the Southwest APC network start positioning? And whether the Tinubu presidency makes any public statement distancing itself from or supporting Aiyedatiwa's expected Supreme Court appeal. The electoral implication. If Aiyedatiwa is ultimately barred and cannot appeal successfully to the Supreme Court, it creates a wide-open 2028 Ondo governorship race. In a state where the PDP's Agbola Ajayi was competitive in 2024, an APC primary battle could fracture the party enough to hand the opposition an opening. This is a scenario that national APC strategists will be acutely aware of. And here is where this case stops being a local Ondo story and becomes a national precedent with consequences for every Nigerian state. But first, we need to talk about what is happening right now in every Nigerian market and petrol station, because a distant war is reshaping the economic context in which all of this politics is playing out. If what you've just heard surprises you, drop your take in the comments. I want to hear your perspective before we get to the part of this story that most Nigerians haven't connected yet. The constitutional precedent, why every Nigerian should care. This case is not just about one governor in Ondo State. If the Supreme Court ultimately upholds the lower court rulings, it will establish a binding precedent for how Nigeria treats succession governors across the federation. Consider this. Nigeria has a history of governors dying in office, becoming incapacitated, or being impeached. Their deputies inherit the position and complete the term. Under this precedent, those successors would face the same one-term limitation, regardless of how brief their completing tenure was. This reshapes the incentive structure of Nigerian gubernatorial politics fundamentally. It could discourage strong political figures from accepting deputy governorship positions in a sitting governor's final term. It could create constitutional ambiguity every time a succession event occurs. Nigeria needs clarity on this question, not a patchwork of lower court decisions, but a definitive Supreme Court ruling. The Iran war and the petrol price crisis. On February 28, 2026, the United States and Israel launched coordinated military strikes against Iran. The conflict disrupted the Strait of Hormuz, the narrow waterway through which approximately 20% of global seaborne oil flows. Within days, Brent crude surged past $100 per barrel against a pre-war price of around $70. Nigeria's 2026 budget was predicated on a benchmark of just $64.85 per barrel. For Nigerians, the paradox is painful and familiar. Nigeria produces crude oil in significant quantities, yet imports virtually all of its refined petroleum. The Dangote refinery, while now operational, is still in a ramp-up phase and cannot yet meet full national demand. The result? Petrol prices that had edged toward 840 to 890 naira per litre have now surged past 1,250 naira in many parts of the country in under 3 weeks, a jump of nearly 35% in under 3 months. Al Jazeera's analysis of global petrol price increases since February 28 found Nigeria at the top of the list with a 35% price spike, ranking third globally. A country that sits atop oil reserves is paying war prices for petrol. That is the structural failure that this Iran conflict has once again exposed. The citizens' reality. The chain reaction is already in motion. Transport fares are rising, food distribution costs are climbing, small businesses running on generators are being squeezed. Nigeria's inflation, which had eased slightly to 15.06% in February 2026, according to the National Bureau of Statistics, is now under new upward pressure. Bloomberg reported this week that the temporary respite consumers felt in February is already being eroded by the fuel price surge. Governance and democratic trust. On the constitutional side, the Aiyedatiwa case erodes a specific form of public trust, the trust that Nigerian voters have in their own electoral choices. The man they chose in 2024 may be structurally barred from asking for their vote again. Whether or not you support Aiyedatiwa, the principle matters. Democratic legitimacy is weakened when courts rather than voters determine who can compete. These two stories, the courtroom battle in Ondo and the petrol price crisis from the Middle East, are connected by a single thread: Nigerian citizens absorbing the costs of systems they cannot control. Nigeria's global reputation on rule of law. International observers watching Nigeria's judiciary are tracking this Aiyedatiwa case for a specific reason.
It is a test of whether Nigerian courts can apply the constitution to a sitting, popular, elected governor without political pressure reversing the outcome. If the case proceeds through the Supreme Court transparently and the ruling is respected, whatever it is, it strengthens Nigeria's democratic reputation. If political pressure distorts the outcome, it reinforces narratives about institutional fragility. The Iran War, Nigeria's strategic position. While the crisis carries a domestic cost, it also creates a short-term fiscal opportunity. Higher global oil prices, potentially reaching $150 per barrel if the Strait of Hormuz remains disrupted, according to economists, mean increased export revenues for Nigeria. The government's economic management team is actively reviewing options. The window for channeling windfall revenues into domestic refinery infrastructure and the Naira for Crude program is now open. On February 13, 2026, just weeks before the Iran conflict, President Tinubu signed an executive order intended to accelerate energy sector reform. That reform agenda takes on new urgency now. The diaspora perspective. For Nigerians in the UK, US, and Europe, the Iran war creates dual concerns. The cost of remittances is affected by Naira volatility, and Nigerian students and workers in Iran and the Gulf region face safety and evacuation questions. The federal government has confirmed it is moving to evacuate Nigerian students in Iran. The diaspora, already stretched by the cost of living crises in their host countries, is watching Nigeria's response closely. But before we can assess what comes next, we need to clear away the noise, because both stories have been surrounded by misconceptions that are shaping public debate in the wrong direction. The court has already banned Aiyedatiwa from running. This is partly true and partly misleading. The Federal High Court has ruled him ineligible, but this is not a final, binding, unappealable judgment. Aiyedatiwa has a clear path to the Supreme Court of Nigeria, and the Supreme Court, as the apex court, is the institution that will deliver the definitive constitutional interpretation. Until that ruling comes, the legal battle is not over. What the current rulings have done is shift the burden onto Aiyedatiwa, having lost both at the Federal High Court and at the Court of Appeal. Myth 2. This case was filed to help the opposition. The evidence does not support this. The plaintiff, Dr. Egbualo, is an APC chieftain. The APC is named as a defendant because the suit also has implications for who the party can field as its candidate. This is entirely an intra-APC dispute. The PDP and Agbola Jai's camp did not initiate this. They are observers who stand to benefit if the APC fractures, but they are not the architects of this legal challenge.
Myth 3. Nigeria will benefit overall from higher oil prices, so the Iran war is good for us. This analysis is incomplete. Yes, higher crude prices increase export revenues, but Nigeria's refining deficit means those gains are offset by the domestic cost of imported fuel. As one Nigerian economic analyst put it, while Nigeria may see short-term revenue gains on the oil side and is better cushioned than before, the net economic impact could still turn negative if the conflict deepens. The structural paradox remains. Nigeria exports crude, imports refined products, and ends up paying more for fuel every time global prices rise. Until domestic refining capacity closes that gap, this paradox will repeat with every major geopolitical shock. What the available evidence actually shows. On Aiyedatiwa, the courts have consistently found the suit admissible and the constitutional argument substantive. The case rests on credible precedent, the Supreme Court's own ruling in Marwa versus Nyako. The legal risk for the governor is real. On the Iran war, Nigeria is in the worst structural position possible for an oil crisis, exporting crude but importing its finished fuel products. The short-term revenue gain cannot compensate for the inflationary pressure that fuel price spikes impose on millions of households. Now, understanding what is actually true, we can look at what is most likely to happen next. Aiyedatiwa appeals to the Supreme Court and wins. This is the most politically stabilizing outcome. The governor files an appeal, which his team has indicated is likely,
and the Supreme Court rules that his completing tenure was too brief to trigger the Section 182.3 limitation, or that the constitutional intent was to protect against prolonged succession tenures, not brief ones. This reading exists within legitimate constitutional jurisprudence. If the Supreme Court rules this way, it will create a clear precedent protecting succession governors who serve brief completing terms. Scenario 2. The Supreme Court upholds the lower court rulings. This is the higher constitutional risk for incumbents across Nigeria. Aiyedatiwa becomes a lame duck governor with 3 years remaining, powerful enough to govern but unable to build political capital around a re-election campaign. The 2028 Ondo APC primary becomes the most contested internal race in the party since the Akeredolu-era succession battles. PDP's chances of reclaiming Ondo State increase materially. Scenario 3. Political settlement outside the courts. This is the scenario few are discussing publicly. If senior APC figures, including those connected to the presidency, decide that the legal uncertainty is damaging the party's position in Ondo ahead of 2028, there could be a political negotiation. Aiyedatiwa steps aside from a re-election bid in exchange for significant influence over the selection of his successor. This would allow the party to manage the transition without a messy Supreme Court battle, while giving the governor a dignified exit. The signals to watch. Watch whether Aiyedatiwa files a Supreme Court appeal within the next 30 to 60 days. Watch whether the Tinubu presidency makes any public or back-channel signal of support or withdrawal. And watch whether any senior Ondo APC figures begin publicly positioning for the 2028 race, because that will tell you whether the internal power brokers have already decided that Aiyedatiwa's political career is effectively over. On the Iran front, watch the Strait of Hormuz. Any ceasefire or diplomatic opening that reopens the strait will ease global oil prices quickly. But if the conflict persists beyond 90 days, the structural inflationary damage to Nigerian households could be severe and politically destabilizing for the Tinubu administration. The surprise insight for this section. Here is what most analysts have missed. If oil prices remain above $100 for 6 months, the Tinubu government may actually be under pressure to reinstate some form of petrol price intervention, not a full return of the old fuel subsidy, but a managed price mechanism, precisely because the political cost of uncapped petrol prices during a foreign war could outweigh the fiscal cost of partial intervention. Watch for signals from the Finance Ministry and the NNPC on pricing policy in the next 6 weeks. We opened with a question. When a sitting governor is barred from re-election by a member of his own party and ordinary Nigerians are paying war prices for petrol they shouldn't be importing, who is running this country and in whose interest? The Aiyedatiwa case answers the first part of that question with uncomfortable clarity. Nigerian courts, when functioning independently, are capable of applying the Constitution against sitting executives. That should be a source of institutional pride, even for those who support the governor. The process is working. What the case also reveals, however, is that internal party discipline in the APC is weaker than public unity suggests. Governors face constitutional challenges from within their own structures. That is a governance risk, not just a political one. The Iran war answers the second part of that question equally uncomfortably. Nigeria's citizens remain structurally exposed to every global shock, not because Nigeria lacks resources, but because successive governments have failed to build the domestic industrial infrastructure that would insulate ordinary Nigerians from foreign price cycles. The Dangote refinery is a step in the right direction, but one refinery in a country of 220 million people in the middle of a global oil crisis is not energy security. The 3 analytical conclusions from today's analysis. 1. The Aiyedatiwa eligibility case is not over, but the governor now fights from a significantly weakened legal and political position, and the APC succession race for Ondo 2028 has effectively begun. 2. Nigeria's petrol price crisis is a symptom of a structural refining deficit that the Iran war has simply made impossible to ignore. 3. Both stories point to the same governance challenge: institutions that work inconsistently and citizens who absorb the costs when they fail. Naija Update 247's position: Nigeria's democratic future depends on courts that apply the Constitution without fear, governments that build the infrastructure their citizens deserve, and citizens who hold both accountable. Share this video with someone who thinks Nigerian politics is too complicated to follow. It isn't. You just need the right analysis. And drop your answer to this question in the comments. Should a governor who completes a dead man's term and then wins a full election count as one term or two? Your answer shapes the future of Nigerian democracy.